Hello everyone, welcome to another interesting and informative session of the Analyst brought to you by Vajiram and Ravi. In today's video, we will discuss 5 important topics as featured in the Hindu and Indian Express for your larger understanding of the current affairs. The topics are as follows. In the first article, we will read about the evolution of basic structure of the Constitution and its significance. In the second article, we will inquire about the causes of student suicide in the country, followed by the third article where we will try to understand the new rules for payment aggregators. Then in the fourth article, we will read about the National Judicial Appointment Commission which has resurfaced in the news. And finally in the fifth article, we will study about the MINAMATA Convention. Towards the end, there will be news snippets especially curated for you to help you excel in the upcoming prelims examination, so stay tuned. With ongoing elections, various debates have surfaced on changing the basic structure of the Constitution to incorporate the transformations which are taking place in Indian society. The basic structure of the Constitution forms an important component of your GS2 paper under the theme of evolution of the Constitution. So before we begin to examine the evolution of the basic structure, first keep a very important thing in your mind, that under Article 368 of the Constitution in Part 20, it deals with the power of the Parliament to amend various provisions of the Constitution. Now the year was 1951 and the Constitution had already come into force on 26th of January 1950, which had actually provided for fundamental right to property under Article 31 of the Constitution. Keep this in mind that now the fundamental right to property is not a fundamental right, rather it is only a legal right, and that has been done from the 44th Constitutional Amendment Act of 1978. However, at that time the right to property was a fundamental right. Now imagine yourself as a government who wants to take a development measure such as creation of a national highway from point A to point B. However, within this track which has been advised to you by the planning department, there lies property of people such as C, D and E. Now to create this national highway, if you will go on for the acquisition of the property, it can violate the fundamental right of people such as C, D and E. Also, there were certain states such as Kerala and Tamil Nadu who were envisaging to introduce land reforms, because at that time a large section of land was actually upheld by the traditional zamindars of the colonial era. And the large amount of peasantry did not had any land rights or any land to cultivate, and thus they were living in poor and destitute condition. Thus, following the socialistic principle of the Constitution, the first Constitutional Amendment Act of 1951 was enacted, which introduced the 9th schedule to provide for inclusion of certain acts such as land acquisition acts and prevented them from any kind of judicial scrutiny, thus raising the question that whether the power of Parliament to amend the Constitution under Article 368 also involves the power to amend the fundamental rights which has been guaranteed by the Constitution itself. This question was raised in Shankari Prasad case of 1951, where Supreme Court held that yes, indeed, Parliament can amend the fundamental right. Also, it held that the term law under Article 13 basically says that if there is any law which has been made by the government and if that is inconsistent with the fundamental right, then that law shall be declared void. However, Supreme Court held that the term law under Article 13 does not include the constitutional amendments by the Parliament. Thus, under the 17th Constitutional Amendment Act of 1964, the government further added several state acts dealing with land reforms, land acquisition in the 9th schedule, preventing them from any kind of judicial review. And this power of Parliament to amend the fundamental right was again upheld in Sajjan Singh case of 1965. However, this took an overturn when Supreme Court reversed from its earlier judgment in the Golaknath case of 1961 when it was examining the validity of 17th constitutional amendment, where it held that no, fundamental rights are actually given transcendental and immutable position under the constitution, and thus Parliament cannot abridge any fundamental right. This judgment under the Golaknath case of 1967 is also considered as the origin of the judicial activism doctrine of the Supreme Court, which ultimately led to the tussle between the government and the court. Then, the government responded with the 24th Constitutional Amendment Act of 1971. Keep this in mind that now the Indira Gandhi government had come into the power with popular slogans such as Garibi Hatao, and the government at that time held absolute majority of having almost 350 seats out of the total 540. Thus, the government enacted and amended the Article 13 and Article 368 both. And now it held that Parliament can amend any fundamental right. Now, this act of the government was examined by the Supreme Court in the landmark judgment of Keshwanand Bharti case of 1973, when the largest bench of Supreme Court comprising of 11 judges was constituted, and it was led by the Chief Justice of India at that time, S.M. Sikri. The case revolved around the Keshwanand Bharti, who challenged the Kerala government's attempt to actually acquire his mutt property through two Kerala Land Reforms Act. And the major violations which were in the consideration were such as the violation of fundamental right to religion, of religious domination, as well as you guys can see here, the fundamental right to property under Article 31. In this landmark judgment, Supreme Court held that yes, Parliament can amend fundamental right. But at the same time, it also held that Parliament cannot abridge or take away the parts which are fundamental to the idea of India, thus laying down the basic structure doctrine. Thus, to contemplate with the government, the Supreme Court at that time took a middle path. It said, yes, you can amend the fundamental rights indeed, but at the same time, you cannot take away the basic structure of the constitution. However, the Parliament again responded with the 39th Constitutional Amendment Act of 1975, under which it kept the election of President, Vice President, Prime Minister and the Speaker of Lok Sabha beyond the scope of judicial review. Now, the doctrine of basic structure was first utilized in the Indira Gandhi versus Raj Narayan case of 1975, where the electoral victory of Indira Gandhi was challenged. And here, the Supreme Court, it struck down the 39th Constitutional Amendment Act of 1975 by holding that free and fair election forms the part of the basic structure, and thus you cannot put a blanket of judicial review over that by keeping the election of President or Prime Minister beyond the scope of judicial review. Then obviously the emergency was declared, and the government took an extreme step at that time by enacting the 42nd Constitutional Amendment Act of 1976, which is also considered as the mini constitution because of the significant amount of changes it brought to the structure of the constitution. Along with that, it also introduced that the constituent power of Parliament is actually unlimited. So we can amend anything from fundamental right to DPSP to fundamental duties to the changes made in preamble, and no such amendment can actually be questioned in any court across the country. Thus, This provision again came under the examination of Supreme Court under the Minerva Mills case of 1980, where Supreme Court held that the amending power of the Parliament under Article 368 is a limited power and not absolute power, because the Constitution itself limits the amending power of the Parliament, as it provides for various kind of special majorities which are required to amend significant provisions such as fundamental right, DPSP, etc. Thus, under the Minerva Mill case of 1980, Supreme Court synthesized the principles of parliamentary sovereignty, under which under Article 368, Parliament can amend any part of the Constitution, that is true. But at the same time, it also held the judicial supremacy, under which the Supreme Court under Article 13 and 32 can judicial review any of such enactments being made, and if there is any act which is ultra vires or unconstitutional, then the Supreme Court can declare that act as void. Now, under the various judgments of Supreme Court, the scope of basic structure has been further expanded. We will look into some of the prominent Supreme Court judgments. First of them obviously being the landmark Keshwanand Bharti case of 1973, under which Supreme Court held that several elements forms the part of basic structure which cannot be amended or taken away by the Parliament, such as the supremacy of the Constitution itself, then the separation of power as envisaged under Article 50, which envisages for separation between judiciary and executive, then to create a republic and democratic form of government, the federal character of the Constitution, the secular character of the Constitution, and finally the mandate to build a welfare state under Article 38 of the Constitution. In Indira Gandhi versus Raj Narayan case of 1975, Supreme Court held that free and fair election forms the part of the basic structure, along with secularism and freedom of conscience and religion, rule of law as established by Article 14, judicial review as established by Article 32. Then in Minerva Mills case of 1980, Supreme Court held that the Parliament has a limited power to amend the Constitution, and there shall exist a harmony between fundamental right and directive principle of state policy, because the government has been enacting this land reform or land acquisition, and it was giving this argument that we are doing this to implement the directive principle of state policies such as under Article 39 of the Constitution. So, Supreme Court held that there shall be a harmony between DPSP and fundamental rights. Then, in Kumar Padma case of 1992, Supreme Court held that the independence of judiciary is also an essential feature of the Constitution, which is obviously very much important to uphold the democratic features as well. Then, in S.R. Bommai case of 1994, Supreme Court held that federalism, secularism, unity and integrity of the nation, and the social justice, all of this forms the part of the basic structure of the Constitution. Then there has been several criticism of this basic structure. That first of all, it is completely vague and not defined. Then it is extra constitutional because it was not in the original Constitution, and judiciary has done its overreach or has gone into the direction of judicial adventurism and has introduced this new concept in our Constitution. Then the definition and its implementation completely lies on various directives by the Supreme Court. However, the basic structure is very essential for our country because of the significance it holds. First of which is that it ensures that the brute majority in the Parliament, it does not translate into the tyranny of the executive. As we saw that when the Indira Gandhi government had absolute majority, it eventually led to just violating various democratic and republic features of the country and trying to completely overhaul the judiciary of the country itself by creating a blanket from judicial review. Thus, to prevent such tyranny of executive, the basic structure doctrine acts as a shield towards us. Then it also creates an embargo upon the unlimited power of the Parliament. where parliament can tomorrow enact any law. Let's say it enacts a law that whoever the person is watching this video, that person is not going to appear for the examination or anything like that. Now, to prevent such vague and overreach of the government, there is judiciary and the independence of judiciary, which is again an essential feature to ensure the democracy of the country. The third is the achievement of egalitarian society based upon the principles such as liberty, equality, and obviously the fraternity. Then, to ensure the judicial independence, which is again an essential form to ensure that democracy prevails in the country. Because let's say that tomorrow comes a government with absolute majority and it says that from now onwards there is no need of election to take place, and it amends the constitutional provisions which provides for free and fair election as an essential principle to democracy. Then we can just simply convert from democracy to dictatorship overnight. However, that will not happen because free and fair election forms the part of the basic structure doctrine. Then it also strikes the balance between the individual rights originating from the principle of capitalism and the collective rights under the principle of socialism. Thus, as per eminent political jurist N.A. Palkhiwala, the constitution is just like our body. Just like how if there is something good which is required by our body, we adopt it, and if there is something bad or something which can affect our body, we discard it. Similarly, the constitution is called as a living document under Article 368 of the constitution by B.R. Ambedkar himself. Thus, if there is some changes which are happening in the society, the constitution will reflect it by doing amendments. At the same time, there are certain basic needs of our body, such as air, food, oxygen, water. Similarly, there is a basic structure which ensures that the idea of India keeps alive, and the judiciary plays a very important role in that. Thus, with these suggestions, try to solve this mains question which appeared in 2019. And we move forward to the next news. The lead article highlights the growing social issue of student suicide in India, significantly hampering India's demographic dividend. Thus, this grave issue of student suicide forms an important component of your GS1 paper under the larger theme of social issues which are denting the fabric of our country. Suicide is a tragic and untimely loss of human life, all more devastating and perplexing because of it being a conscious volitional act. Just imagine the student of 15 to 16 years getting into that stage of their life where they are ready enough to end the most precious gift of their life, that is the will of living itself. This grave issue is actually expanding its wing in our country, where India holds the dubious distinction of having the highest number of suicides in the world. As per National Crime Record Bureau's report, India accounted for 1.7 lakh deaths due to suicide in 2022 itself. And majority of them is actually the younger lot, as can be reflected from the statistics, where according to the Ministry of Social Justice, more than 35,000 students committed suicide between the year of 2019 to 21. And their numbers has been consistently increasing in the last few years, as can be seen from the table. Now, many of the people actually associates the student suicides to their failures in their life. However, this is not true, because as we can see from another table, the students from prestigious universities such as IITs, NITs and IIMs, even there the number of suicide has actually been increasing. Now, what we will do with the fundamental rights which we were discussing about, such as fundamental right to dignified life, if the people does not have will to live itself? Well, according to the sociologist Durkheim's theory of suicide, the suicide is actually the result of various complex issues. such as the one being the poverty of aspirations. As per the Multidimensional Poverty Index of 2023, there exist more than 23 crore multidimensionally poor people in our country. And the only way for these poor people to break the cycle of generational poverty, the easiest recourse which these parents can think of is to invest in their child's education. Thus, either these children are enrolled in the government-funded schools which are mired with poor infrastructure, or these parents, they take exorbitant loans to fund the education of their children. One of the major reasons being that education is considered as a gateway to the land of riches in our country, which is actually the theory which is further being propagated by the poster boy syndrome, where various coaching institutions, tuition classes, and all of that economic structure which has been created around the education, it actually propels this idea of poster boy, or the person who has significantly transformed their lives overnight just because they have got a rank in a prestigious institution or have cracked some government exam. They sell these dreams to millions of people to actually fund their own pockets. Then all these students, and majorly because of their families, they dream of these coveted government jobs or sarkari naukri, which will obviously eventually transform their life. And another major reason is, for such high competition or enrollment in these selective few examinations, the reason for that is to escape the social, caste and class predicaments from which these students are being exposed since their childhood, thus ultimately leading to the issue of relative deprivation, which has further actually enhanced in the recent years due to the significant penetration of internet as well as the rise of social media, where if you'll go on YouTube and just see one government officer's entry, the algorithm will start targeting you in a way that you will be flooded with plethora of such videos, where from day to night you will be just watching the luxurious and glorious life of these selected few people who have cracked some prestigious examination or have got into some prestigious universities, and thus act as a constant reminder to you that how your life in comparison to them is actually in destitute condition. And this glorification of those selected few actually starts leading to the issue of relative deprivation, which obviously further compounds by the loopholes which exist in our education system, which instead of being value based, it is completely marks based merit system, obviously induced as a gift by our colonial legislators. Then there exists a throat cut competition within this education system, where your capability or merit to succeed in future in your life actually is completely based upon the numbers you will get in your report cards, where if your years of hard work does not translate into the final roll number in the result of these some prestigious institution or some government examination, then you will suddenly become the burden not only on the family but society as well. Thus, this constant pressure which has been induced in the student's mind, it eventually starts translating into social apathy and social anxiety, which is obviously further aggravated because of the role of institutions. Institutions such as schools, colleges, coaching institutions, all of this who actually act as large impersonal spaces, where there obviously exists less coordination between the peers, teachers and administration, where the student is completely told to take participation in this throat cut competition, to do the labor work for hours, let's say 8 hours of school followed by 5 hours of coaching, then 2 or 3 hours of self-study, ultimately deteriorating that person's self-confidence and self-esteem. Then obviously there is less expertise or empathy among the teachers and professors to actually understand what a student is facing, to identify the early signs of distress. And then all of these institutions, majority of it at least, they act with tragedy augured, action triggered approach, where unless and until some student has actually committed such extreme step in their life, till then these institutions, they remain reluctant to provide these students with any kind of mental health support. Obviously all of these issues are aggravated by the role of parents, because all is well unless and until you get back home and you have an emotional support and appreciation system in the form of your parents. However, these parents, they just keep the insurmountable burden of expectation on these students, where these students are constantly reminded of the investments which are being made in them and how they shall turn into assets for their future, the future of their parents, and the request or the constant warning that please do not turn into a liability for us. Further, this emotional support deficit has actually started increasing because of the generational gap which has widened, and at the same time with the rise of nuclear family structure, the kind of globalized environment in which we are living in, and over a period of time there exists a kind of a emotional differences between the parents and children, where the children have become much more excluded and secluded from the larger structure of society. Also, over a period of time, the students, they start developing this no turning back mentality, where because of this constant societal pressure which has been put on them to get the rank, to get on those posters, these students, they start thinking that this examination is actually bigger than their life itself. Thus, the whole idea of their happiness, of their self-worth, all of that actually starts getting dependent on clearing this examination, in a process of which these students, they face a lot of challenges, such as discrimination on the basis of religion, race, their caste, their color, and many a times their financial status as well. Then when the student at such young age, now the people, they have started competing for examinations from the class 6th, class 7th itself, right? I don't think that time is far away when the people will start preparing for JEE or NEET by the time they get into, they get 3 years old. And I hope the 3 years old does not be considered as too late for some students in the future. Thus, at such young age, when these students migrate from place A to B, they also faces dietary changes and cultural shocks, which is too much for them or too overwhelming for them to absorb at some point. Because of all these factors, over a period of time, they start developing the imposter syndrome or constant self-doubt, which ultimately deteriorates their mental health, where they start feeling frustrated, they start getting depressed, they have no one to share to, because obviously you will not share to your competitors, with the people you are living. Then you cannot share that with your low marks with your parents back at home, because they are in this constant need of you performing and succeeding in your life. And this habit which we are induced to from our childhood itself, right, that if the guest has come, go in the front of them, dance, they will clap for you. So because of this induced mentality, there is a lot of rising mental health issues among the students, which can also be depicted very well from this picture, where the picture says that yes, even though we have become such smart engineers, we have not yet been able to devise a kind of an instrument which can actually measure the mental pressure these students go through. Thus, to deal with such grave issue, the government has taken several steps. First of which is the National Suicide Prevention Strategy 2022, which was launched by the Ministry of Health and Family Welfare, which ultimately aims to reduce the suicide by 10% by the year of 2030. Then the UMEED guidelines were launched in 2023. UMEED, which stands for understand, motivate, manage, empathize, empower as well as develop these young students. These UMEED guidelines act as a kind of instructions to the schools where they shall create an early distress system. They shall sensitize the teacher as well as provide for mental health support. Also, several high and prestigious institutions, they have taken this step where they have integrated the online platforms to provide for this mental health support and to create groups or communities where these students can actually express themselves. The example of such apps are Dost and Mitra app. The Rajasthan government, the part of which there is a very large coaching industry which exists, it has also taken several measures, such as it has provided for stricter rules for coaching institutes, such as they are now not allowed to enroll the students before class 9, or they shall create a mental health support system. Also, the test results are now not allowed to be declared publicly. Then there is Manas app, which actually helps the students to ensure and prevent their mental health. However, there are certain other steps which shall be taken, such as first and foremost to create the feeling of home away from home, where these institutions, teachers, mentors, all of them shall come across one board to ensure that the student actually feel comfortable and confident. And this can be done through dedicated counseling sessions, especially adopting the European model of schools, where they held regular counseling sessions by the trained professionals. Then obviously we shall need to incorporate the social workers to develop impersonal understanding among the students, to give them the larger viewpoint of the society which exists. And there shall also be incorporation of the guidelines of National Education Policy of 2020, which envisages for value-based education system as well as flexible academic credit routine. And then we shall need to create awareness about the alternative career options. As per a report of Ministry of Education, when it was created a survey, it was actually revealed that 94% of the students were only aware about 7 streams or career options. Only 7. So there shall need to generate awareness, to provide them awareness that there are alternative career options as well. Engineers, doctors and lawyers are not the end of the life, so that they understand that the fate of the world is not riding on their scores. With these suggestions, we move forward to the next news of the day. Following the guidelines of June 2022 to better regulate the online payment aggregators who are facilitating the proximity transactions or face-to-face transactions, RBI has framed the draft rules for these payment aggregators, who forms an important component of your GS3 paper under the theme of banking sector. So let's first try to understand who are these payment aggregators. Payment aggregators are basically the entities who help in settling down the payment between the merchant and the customer, thus making sure that these merchants, they are not overburdened by setting up their own integrated payment system and increasing their cost of operation. To understand which, let's say that there is a payment aggregator and here is a customer, and customer makes a payment order through UPI. Then this payment aggregator will do the authorization request to the partner bank, which is basically an escrow bank. What is an escrow bank? Let's say that I am a person A and you are a person B, and I am providing certain service to you. For that you need to give me payment on, let's say, 28th of April. But I am not sure that on 28th of April whether I will get my payment or not. So what I do, I tell you to create an account in C, that is an escrow account, and keep the money which you need to give me there. Thus, when I will provide the complete service to you, then I will take my payment from there. Thus, I will have a surety that I will get my payment. Similarly, the escrow bank will do the authorization request to the payer's bank, and the payer's bank will provide the customer the money. And the transfer of the payment will take on the settlement date to the merchant bank as well. Thus, payment aggregator is acting and incorporating various modes of payment. And there are different types of payment aggregators, such as third-party payment aggregator or a bank payment aggregator. And these PAs are regulated under Payment Settlement System Act of 2007 and is overall regulated by RBI, which has also issued guideline in 2020 March to regulate both payment aggregator as well as payment gateways. Now, what is the difference between them? Well, the difference between PAs and payment gateways are that payment gateways are basically the secure passage for transmitting the customer payments information between the merchant's website and the bank's processing system, where it provides for verification and encryption of sensitive data such as, let's say, the credit card details. The example of these payment gateways are HDFC Pay or ICCI Gateway, etc. On the other hand, as we discussed, the payment aggregators act as a platform which aggregate the various payment modes and are also involved in the transfer of the funds, where they provide several kind of payment options such as credit card, debit card, United Payment Interference, net banking, etc. Example of such payment aggregators are Paytm, PhonePe, etc. Now, what are the new rules which has been drafted by RBI for these payment aggregators? The first is that it has laid down the criteria for approval of any non-banking entity to get the application or to get the perform as payment aggregators. The reason for that is because of the recent debacle which has taken place with the Paytm bank. So now under the new rules, if there is a new non-banking entity, it has a net worth of 15 rupees crore in the first year, then it can apply to become a payment aggregator. And over a period of time, RBI is going to extend this entry limit to 25 crore by the year of 2028. However, if there is a new applicant, then that person needs to have the net worth of 15 crore. And by the third financial year, that net worth of that non-banking entity shall increase to 25 crore rupees. Now, the people who are providing point of sale services, they shall inform 60 days prior to RBI before the RBI releases to include the application circular forms. Also, the on-board merchant, they shall not collect and settle funds for services which are not offered by them on that particular platform. The Know Your Customer norms was mandatory and now it has become much more stricter because there was a lot of violation of these KYC norms in the payment banks apps, Paytm apps. Also, the new rules provide for data localization, where no entity other than the card network or the credit card service provider, no entity other than that can store the data from August 1, 2025. Only a minimal amount of data can be secured or stored, such as the 4 digits of credit card, and only such meager amount of data will be localized and stored. Rest of the data shall be purged by these companies. Then the new rules also provide for the categorization of merchants, such as small merchants who have only physical presence and their annual turnover is less than 5 lakh rupees and they are not registered under the GST regime. These small merchants shall be done with contact point verification, or there shall be a physical verification which shall be done that whether such company actually exists or not. Then the second category is of the medium merchants who have both physical and online presence, and their annual turnover is more than 5 lakh rupees but less than 40 lakh rupees. And such medium merchants are also not registered under GST, and for them as well there shall now be the contact point verification. Further, the RBI has directed these entities to adhere to the guideline on merchant onboarding basis, customer grievance redressal, baseline technology recommendation, security and fraud prevention, as well as risk management framework. Thus, RBI has strictly took steps to further strengthen the payment frameworks in our country to ensure that the debacle which took place with the payment bank, that is not repeated. Keep these important provisions in your mind and we move forward to the next news. The Supreme Court recently rejected the plea asking for the resurrection of NJAC or National Judicial Appointment Commission and for the abolition of the collegium system, considering it as that the case has already been heard, evaluated and the justice has been served, and thus there is no need to further resurgence of this NJAC at the national debate platform. NJAC forms an important component of your GS2 paper under the theme of judiciary. Now, before we dwell into the debate, first try to understand that under Article 124 of the Constitution, the Chief Justice of India is appointed by the President. And under Article 126 of the Constitution, the other judges of Supreme Court are appointed by the President in consultation with CJI and other judges as he shall seem fit necessary. Now here keep a very important word in your mind, and that is consultation. So when President is appointing the other judges of Supreme Court, he needs to consult with CJI as per the Constitution. The controversy arose on this term itself, leading to the evolution of collegium system through the judges' cases. In the first judge's case of 1982, the Supreme Court held that the consultation does not mean concurrence. So it is only limited to consultation. So let's say if I am the President and you are the Chief Justice of India, I ask you whom shall I make the next judge? You say make the person A the judge. I say okay, I will think about it. I am consulting with you, but it is not binding on me. Thus, according to the first judge's case, the consultation only implies the exchange of views. However, in the second judge's case of 1993, the Supreme Court held that consultation means concurrence, which means that the advice tendered by the Chief Justice of India on the appointment of other judges is actually binding on the President. And such advice shall be based upon consultation with the two senior most judges of that time. Now, keep this in mind that from 1950 to 1973, the Chief Justice of India was appointed on the precedent that the senior most judge will actually become the CJI. But in 1973, for the first time, this precedent was actually violated when A.N. Ray was appointed as CJI, superseding the three senior most judges of that time, and then in 1977 M.U. Beg was made CJI, then superseding the senior most judge of that time. But in the second judge's case of 1993, the Supreme Court held that only the senior most judge of the Supreme Court will now be appointed as the Chief Justice of India. Then in the third judge's case of 1998, the Supreme Court held that the consultation shall actually include the plurality of judges, and leading to the formation of a collegium system where now the appointment of judges will be based upon the recommendation of Chief Justice of India and four senior most judges. Even if the two judges give the adverse opinion, then the CJI shall not send the recommendation to the President. However, this collegium system, which has been devised by the Supreme Court to ensure its judicial independence, it has also come under a lot of criticism, where obviously it is said to be a non-constitutional body. as well as it leads to the violation of principle of the separation of power as envisaged under the Article 50, which lays down that there shall be separation between judiciary and executive. Also, there exists a lack of transparent system, that how these judges from High Court, they are being appointed to the Supreme Court, on what basis, what is the basis of their merit for such appointment. All that remains in the blanket of invisibility for the common man, and thus there also arises the claim of nepotism which is taking place under the appointment of judiciary. Thus, to deal with such criticism, the government came up with the 99th Constitutional Amendment Act of 2014, under which it led to the appointment of a National Judicial Appointment Commission, which will comprise of 6 people consisting of Chief Justice of India as the ex officio chairperson, 2 senior most judges of Supreme Court, as well as Union Minister of Law and Justice. And then there will be 2 eminent members who will be appointed from civil society organization. At least one of the member will come from SC, ST, OBC, minority or women. And for the appointment of such eminent member from civil society, there will be consisting of a committee which will comprise of Prime Minister, Chief Justice of India and the leader of opposition in Lok Sabha. Here, the Chief Justice of India and the Chief Justice of High Court will be appointed on the basis of seniority only. And the other judges will now be appointed on the basis of ability and merit, which will be gauged by this National Judicial Appointment Commission. However, keep this in mind that in the 4th judge's case of 2015, the Supreme Court held this NJC as ultra vires or non-constitutional and thus abolished this commission. However, the debate has been resurfaced with the recent plea which was filed. We need to make sure that there shall be transparency in the appointment of judges, to make sure that such claims of nepotism which are being raised, they are toned down, and we also make sure that the common men who are actually need in the law of the most, they reach to this higher decision making power, such as the person B.R. Ambedkar. With this suggestion, we move forward to the next news of the day. The article highlights the issue of high concentration of mercury in fairness creams, leading to severe health issues and preventive measures under the MINAMATA Convention, which forms an important component of your prelims paper under the larger theme of current affairs. So let's first try to understand the issues related to the mercury pollution. Mercury is a naturally occurring element which occurs in air, water and soil. And it can be emitted from several sources, such as natural being the volcanic eruption, or the anthropogenic being the gold mining, which is the largest source contributing to 37% of emission, or the fossil fuel attraction which take place, or the cement extraction which take place. All of that leads to the emission of mercury. Now, why mercury is in such rampant use? Because of the multifaceted uses, such as in the manufacturing of lamps, or it is highly used in beauty creams because it inhibits the formation of melanin, thus leading to lighter skin tone. Now, obviously, there is this stupid obsession or association of fairness with beauty, which can be seen from plethora of ads where there will be firstly a sad woman just not getting any job, unemployed, facing all the problems in her life. Then she will apply this fairness cream, and overnight she will turn into Snow White, and next day she will become the center of attraction for the world. But because of such rampant use of mercury in these beauty creams and high exposure to mercury, it has several detrimental effects, such as it leads to membranous nephropathy, which is basically an autoimmune disorder where there is high release of protein through the urine, ultimately causing severe diseases, such as NEL1 or the neural epidermal growth factor like protein. which ultimately leads to various health effects such as memory loss, impaired hearing, vision and speech, tremors, lack of coordination, etc. The Minamata disease, which is caused because of the exposure to methyl mercury, also leads to such sense losses such as weakness, fatigue, weight loss which happens, difficulty in chewing and swallowing. All of these health effects because of the exposure to the high concentration of mercury. Keep one thing in mind here, that Minamata disease is caused by the methyl mercury emission and not by ethyl mercury, because ethyl mercury is used as a preservative in vaccines. Then, according to World Health Organization, because of this reason, mercury is one out of the top 10 chemicals of major public health concerns. Now, here we will remember one more term, and that is renin, angiotensin, aldosterone system or RAAS, which is used to treat the chronic kidney disease which is caused by the exposure to mercury. Thus, the Minamata Convention was adopted in the year of 2017 with the aim to control the mercury supply and trade, to reduce the use and emission of the mercury by various industries, and to further raise the public awareness. India ratified this Minamata Convention in 2018, thus becoming the 93rd party. Currently, Minamata Convention has 140 plus member nations. Keep this in mind that even under this Minamata Convention, there has been yet no agreement on the safe exposure to mercury, as there are various claims when it comes to the exposure of mercury. However, Minamata Convention does one good thing, and that is that it sets up one particulate per matter limited for the mercury concentration in the cosmetic products. However, as the report highlights, when it actually evaluated more than 200 plus products in more than 190 countries, it found out that majority of the cosmetic products which we are applying on our skin to become fairer, or for like this man who is actually seeking for a very fair wife in his life, because of these reasons, these companies, they have the mercury exposure of 1.8 ppm to 74,000 ppm. Thus, there is immediate need to further strengthen the Minamata Convention and to curtail the mercury exposure and uses. On the basis of this information, let's try to attempt a Prelims 2023 question, where the first statement says that gold mining activity is a source of mercury pollution. Yes, indeed it is true. The second says that coal-based thermal power plants, use of fossil fuels cause mercury pollution. Yes, indeed. The third statement says that there is no known safe level of exposure to mercury because there has been no yet global agreement which has been created for what is exactly defines the safe level of exposure to mercury. Thus, all three statements are correct. With this, we move forward to the next news segment. In this Prelims Snippets, we are going to cover some important news which are very factual in their nature and can help us in eliminating important statements in the Prelims examination. The first of which talks about the Telecommunication Act 2023, which has been in the news because the government is trying to move to the certain class of spectrum to be allocated through administrative processes now. And the Supreme Court had actually cancelled such telecom licenses in relation to the 2G spectrum scam which occurred, where such administrative allocation of spectrum had actually taken place, leading to that big scam of 2G. Now, what government is trying to do, that it is trying to assign the spectrum for telecommunication through administrative processes other than auction for entities which are listed in the first schedule. And which are the entities which are listed in this first schedule? The entities who are engaged in national security, defense, law enforcement, as well as, keep this in mind, the global mobile personal communication satellite such as Starlink of Tesla. Also, the government is aiming to assign the part of spectrum that has already been assigned to one or more additional entities in bracket of secondary assignees. And it further aims to terminate the assignment if the spectrum remains underutilized for insufficient reasons. All of this will take place under the provisions of Telecommunication Act of 2023, the major provisions of which please keep in your mind. We move forward to the next news, which talks about the Article 39B, a socialistic principle. What Article 39B provides the directive to the state? First, it says that the citizen, men and women, all equally shall have the right to an adequate means to livelihood. For this discussion, we are going to focus on 39B, which says that the ownership and the control of the material resources of the community are so distributed as to best subserve the common good. Now, this debate was taken in the Supreme Court, where the debate revolves around that whether the privately owned resources, that let's say if I own a particular plot in any particular area, let's say Delhi. So these privately owned resources, can this be considered as the material resource of community? The argument which was given by the Attorney General was that yes, all things which are available in the material world, let's say in the country, if the government can claim the right on that, then it equally belongs to the community. However, the Chief Justice of India, D.Y. Chandrachud, raised a very important counterpoint where he said that is there no concept of private property which exists in our country then? Because if all the privately owned resources are considered as community goods, then what will be exact definition of private property? As we have discussed already, currently it is a legal right under Article 300A. And earlier under Article 31, it was a fundamental right, and it was moved to this legal right by the 44th Constitutional Amendment Act of 1978. Keep these important provisions in your mind. We move forward to the next news, which talks about CS3Ds. What is this? This is basically acronym for Corporate Sustainability Due Diligence Directive, which has been launched by the European Union, which is basically a law which requires the large companies who are operating in this 27 countries bloc to check if their supply chain uses any kind of forced labor or cause any kind of environmental damage. Now keep this in mind that if this law will come into effect, also if you remember guys, we discussed CBAM, right, carbon border adjustment mechanism in our last lecture. So if both of these laws will come into play, it can actually significantly hamper 25% of India's export of iron, steel and aluminium which take place towards the European Union countries. Because the tariffs which will be applied here, it will actually raise the cost of export by 20 to 35%, and it can significantly impact the India's target to achieve $1 trillion of merchandise export by 2030, because 25% of it is directing where? To the European Union. So keep this CSDD and CBAM very close to your mind. We move forward to the last news, which talks about the Global Combat Air Program. Well, the article in the news actually covered the significant rise of Japan in 21st century. It also throws light on a very important initiative taken by the Japan, that is Global Combat Air Program, along with other countries such as United Kingdom and Italy, where these countries are trying to envisage to develop a 6th generation stealth fighter. And that will happen with the merging of bi-system Tempest of UK and Italy and Japanese Mitsubishi FX. So earlier they were developing their own 6th generation stealth fighter, but now they have combined the effort under this Global Combat Air Program. Keep this in mind that till now India only has a 5th generation stealth fighter, that is Advanced Medium Combat Aircraft AMCA, which has also been recently in the news. The other similar programs of other countries we are trying to develop this 6th generation stealth fighter is the Next Generation Air Dominance of USA and the Future Combat Air System of France, Germany and Spain. Thus, keep this program very dear to you for the upcoming prelims examination. And with this, we have reached to the end of our discussion today. Do not forget to attempt the questions at the end of the video and test your knowledge. We will meet in a very interesting discussion very soon. Till then, all the very best for your preparation, guys, and thank you.